In this lesson, we're continuing our discussion of the essential elements of almost all crimes. Specifically, we're going to focus on our fourth and final essential element, which is causation. Here we say in order to hold a defendant liable for a crime, the prosecution has the burden of proving that the defendant's voluntary act or omission was the actual and proximate cause of the social harm specified in the definition of the offense. Right? In other words, we're looking for a link between our first element, right? The actus reus requirement. Remember, the defendant's voluntary act and that ultimate social harm specified in the definition of the offense, right? And most often when we're dealing with causation issues, we're dealing with criminal homicide analyses, right? So if we think about this in terms of criminal homicide, and again, important to recognize that this is an essential element, this has to be proven in all crimes, it's just usually less of an issue in crimes outside of criminal homicide. And even within criminal homicide, a lot of times causation is not an issue, right? Tracing the defendant's conduct, the voluntary act to the death of the victim, even in criminal homicide cases, a lot of times is really easy, right? Imagine going back to our wife killing her husband example, right? Husband comes home from work, wife pulls out the gun, shoots him. As soon as he comes in, hits him in the head, and he dies immediately, right? There's no causation issues there. It's very easy to trace the defendant's voluntary act, the trigger pull of the gun, to the death of the victim, to the social harm defined in the definition of the offense. There's no causation issue. We can clearly see how she pulls the trigger. That's her voluntary act, right? Now the bullet comes out of the gun, it enters into the victim's body, and he dies immediately, right? It's very easy to trace element number one, right? That actus reus requirement, the defendant's voluntary act, to the social harm, right? The death of our victim. Right, so where causation can become more of an issue is when that situation, that circumstance gets more attenuated. Right, imagine in that example that the husband doesn't die immediately, right? Let's say he comes home, wife pulls out the gun, shoots him, he gets shot and he gets wounded, but he doesn't die, right? So the ambulance comes and picks him up, and as the ambulance is going to the hospital, the ambulance gets into a car accident, right? And say the husband has more injuries from that. Now he has to have emergency surgery on these new injuries, right? Of course, the doctor messes this up. Now he gets this horrible infection. He fights the infection, but 6 months later, from complications from the surgery and the infection, right now he dies, right? So now our causal chain, right? The causation is harder to see from the defendant's voluntary act of pulling the trigger to this guy getting an infection and then dying 6 months later, right? It's not as easy to see as just pulling the trigger, hit someone in the head, and they die immediately, right? The more attenuated it gets, the more we really have to think about causation, right? And we'll go through how you would actually analyze that fact pattern as we work through examples here and really flesh out the causation analysis, right? But big picture, that's kind of the issues we're looking for when we're thinking about a causation analysis. Again, with most crimes, it's so straightforward, we don't even have to worry about it at all. In criminal homicide, right, this is the area of criminal law where it can really become more of an issue. And again, a lot of the time, it's still not an issue. You point a gun at somebody, hit them in the head, and they die immediately. We don't have a causation issue. We're looking for those attenuating circumstances. Right, so how do we ultimately analyze causation though? Remember, the prosecution has to prove both actual and proximate cause. So we're going to break each of these down, right? Actual cause we have here as our first element, and proximate cause here as our second element, right? So we say causation is satisfied if the social harm specified in the definition of the offense would not have occurred when it did, but for the defendant's voluntary act. And number two, there were no superseding causes of the social harm. Again, element one is actual cause. Element two would be referring to proximate cause. We can break these down each separately, starting with actual cause. So it's probably best to do a really easy example here just so we can see what we mean, this idea of but for causation. This is really similar to torts, right? But it is different, right? But if you remember to torts, if you have some context there, but for causation is really similar to the tort application and negligence of causation. But here, let's apply the wife shooting the husband in the head and he dies immediately example, right? Was the wife the actual cause here? Could the prosecution prove actual cause in that situation? Let's just plug it in, right? Can we say the social harm in the definition of the offense would not have occurred when it did, but for the defendant's voluntary act, right? Well, here, the husband, right, would not have died when he did, but for the wife shooting him, right? But for the wife pulling the trigger to the gun, right? That's very easy to see how she's the actual cause, right? In other words, had she never pulled the trigger to the gun, he would be alive, right? At that moment in time, at least, he'd still be alive had she not pulled the trigger, right? But for her voluntary act of pulling the trigger, right, he would not be dead right now at that moment in time. Right, so that's a really easy actual cause analysis. So where can we have issues with actual cause? Well, number one, we have to be able to distinguish causation and mens rea. And sometimes this can be more difficult than people realize. Let's take a classic example, right? Let's have a room. Where do I have room to draw the room? All right, let's say we have a room like this, right? And let's say there's 3 people in this room, right? Let's say in the middle we have our victim, so I'll write a V, right? And let's say on either side of the room we have 2 defendants, right? We have defendant 1, right? And let's say we have defendant 2. Okay, let's say that defendant 1 has the intent to kill our victim, right? So defendant 1 comes into the room, pulls out a gun, has the intent to kill our victim, pulls out the gun, shoots, but misses the victim, right? So the bullet never touches the victim. But let's say at the same time, on the other side of the room, our second defendant happens to be cleaning his rifle, right? And at the same time, defendant 1 is pulling out his gun and shooting and missing the victim. Defendant 2 accidentally slips while he's cleaning the gun and it fires, right? And defendant 2's gun actually strikes the victim and it kills the victim immediately, right? Question is, are either defendant, defendant 1 or defendant 2, liable for murder with an intent to kill? Right? Let's say murder with an intent to kill is defined as a killing of another human being with the intent to kill. All right, well, let's break down defendant number 1 first. Remember, defendant 1 comes in with the intent to kill the victim. He's got his gun, he's got the intent to kill the victim. So defendant 1 has the mens rea requirement. He has a voluntary act, right? He pulls the trigger to the gun, but he misses, right? So is defendant number 1 the actual cause of the victim's death? The answer is obviously going to be no, right? His bullet never touches the victim, right? The social harm specified in the definition of the offense did not occur for defendant 1, right? His bullet missed. So this victim did not die because defendant 1 pulled the trigger, right? We can't make that actual cause determination for defendant number 1. Right? So defendant number 1 had mens rea, right? He had the intent to kill, but he doesn't satisfy actual cause, right? Defendant number 2, let's go through him. Is he liable for murder with an intent to kill, right? The killing of another human being with the intent to kill. Well, here, defendant number 2 is going to be the actual cause of the victim's death, right? Remember, defendant 2 is cleaning the gun, it accidentally fires and hits the victim, killing the victim immediately, right? So here we would say that the victim would not have died when the victim did, but for the defendant negligently cleaning the gun, right? The victim died when the victim did because the defendant's voluntary act, right? The defendant was negligently cleaning the gun and it goes off and the bullet hits the victim, killing the victim immediately. Defendant 2 would clearly be the actual cause, right? The victim would not have died when the victim did, but for defendant 2 negligently, right, shooting the gun off, right? So defendant 2 is the actual cause. Okay, so defendant 2 has the actus reus, right? He's got the accidental trigger pull, right? So he's got the voluntary physical act, right? And that voluntary physical act was the actual cause of the social harm. So is defendant 2 liable for murder with the intent to kill? And the answer is going to be no, because defendant 2 doesn't have the culpable mental state, right? Defendant 2 doesn't have the intent to kill anyone, right? He's just accidentally messing with the gun and it goes off, right? He has no intent to kill. So defendant 2 is not liable for murder with the intent to kill because he doesn't have the mens rea. Defendant 1 is not liable because he's not the actual cause of the victim's death. So neither is liable for murder with the intent to kill. It's a little bit of a riddle for you. Right, so some of you might be thinking, wait, well, victim's dead, right? Someone's got to be liable. The answer here is, right, defendant 1 would probably be liable for something like attempted murder, and defendant 2 might be liable for some type of criminal negligence, maybe something like involuntary manslaughter or potentially depraved heart murder, depending on the facts. We'll get into all of that later. Right, important to recognize, as I say a lot, you'll hear a theme is, just because you're not liable for one crime doesn't mean you're not liable for any crime. Right, so here defendant 1 and defendant 2 could be liable for other crimes, but neither is liable for murder with the intent to kill. Right, and the whole point of this is to illustrate there is a difference between causation and mens rea. Sometimes they kind of get commingled together. We just really want to make sure we separate those ideas. It's possible to have the intent, right, the mens rea, but not be the actual cause. Just the same, it's possible to not have the mens rea requirement, but be the actual cause, okay? So next up, as far as issues that can arise with actual cause, right? The big one is when there's multiple actual causes, right? This is going to be where you have multiple defendants, kind of like what's going on right here, right? Where we have multiple defendants contributing to the social harm, right? That's where we're going to have some actual cause issues. Now, from the top, it's important to recognize that a lot of times when we have multiple defendants, if they're working together in some capacity, right, they're either, we'll talk about what a conspiracy is, right, later on, so they're either co-conspirators or maybe they're accomplices, and we're really going to flesh out how all of that works, right? So if we have multiple defendants and they're working together, that's going to raise a whole different set of issues, right? And they all might be liable for each other's actions. That's not what we're talking about right here. For our purposes, let's assume that we have multiple actors that are totally unrelated, right? They're not working together, they're not co-conspirators, they're not accomplices, because again, that would raise a whole different set of issues, right? So let's just say we have independent actors, right? But these different actors still contribute to the same social harm, the death of a victim, right? How do we deal with this? Well, the first one we have is accelerating a result, right? If two people, I'm going to go through these pretty quickly because it is rare that these come up, but you want to be aware of it, right? If two people shoot the same person, right, at the same time, if you can show, and usually this would be based on like a medical expert testimony, right? If you can show that this accelerated the death, right, then they're going to be the actual cause, right? Then you can say defendant 1 is the actual cause. If two people shoot the same victim at the same time and a medical expert comes in and says, hey, look, right, defendant 1's bullet accelerated the death here, right, the social harm, then defendant 1 is an actual cause. Same thing would go to defendant 2, right? Just to flesh that out fully, imagine that defendant 1 and defendant 2 both shoot at the victim at the same time. It's just two unrelated actors that both are shooting at the same person, right? Defendant 1 shoots the left leg, defendant 2 shoots the right leg, right? And this person now dies, let's say, in 5 minutes, right? From being shot in the left leg and the right leg, they die in 5 minutes. Well, let's say a medical expert comes and says, look, either one of those bullets alone, right? If he had just been shot in the right leg, it would have taken an hour to die. If he was just shot in the left leg, it would have taken an hour to die. But because he was shot in both legs at the same time, he died in 5 minutes, right? That accelerated result, we would say, okay, both defendants can be held liable, right? Defendant 1 and defendant 2 are both the actual cause, right? Because without this rule of kind of the accelerated result, which is in the language here, when it did, right? Without this accelerated result example kind of built into the language of our element, right? What could they argue, right? In that example, let's say defendant 1 and defendant 2 shoot the respective legs, right? And the person dies in 5 minutes. Well, the social harm specified in the definition of the offense, right? The death of the victim would not have occurred but for the defendant's voluntary act, right? Well, each of the defendants could say, well, wait a second, this victim was going to die anyways, right? He got shot in the other leg by the other guy. He was going to die no matter what I did, so I'm not the but-for cause. He got shot in the other leg by this other defendant, right? And they could both pin it on the other one, and it would be impossible to show that either one was the actual cause because the victim was going to die in an hour anyways. That's why we say when it did, right? The death of the victim would not have occurred in 5 minutes, but for the defendant's voluntary act. Right now, we can show, okay, you accelerated the result. We can say the death would not have occurred in 5 minutes, but for you pulling the trigger on the gun, right? Because you accelerated the result, you are the actual cause. Right, so you want to be aware of accelerated results. Concurrent sufficient causes gets even more confusing, and I don't want to go into too much detail here because different courts handle this differently, and the reasoning changes from court to court. They come up with different ways, but ultimately they all get to the same conclusion, right? If we have concurrent sufficient causes, in that case, both defendants are said to be the actual cause of the victim's death, right? And these are exceedingly rare cases. Imagine it's not an accelerated result. It's two different actors that would have killed the victim immediately. So say that we have a victim in the middle of the street, right? And one actor, one defendant is aiming a gun at this victim's head, and the other actor is driving a semi-truck right at the victim at 100 miles per hour. Well, let's say either one, right? If that bullet hits or that semi-truck hits, this victim dies immediately, right? So, and let's say that the bullet hits the victim in the head at the exact same moment in time that the semi-truck hits this victim, right? And the question is, okay, is defendant 1 or defendant 2 the actual cause of the victim's death? Right here, neither one accelerated the result, right? So we run into a big problem. Both could do the argument we talked about last time, where you could say, hey, look, this guy was going to die at that moment in time, whether or not my voluntary act happened or didn't happen, right? If I didn't shoot this gun, he was still going to die at the exact same moment by this semi-truck. And the semi-truck driver can say the other thing, look, even if I wasn't on the road right now, even if my truck didn't exist, doesn't matter, he was going to die at the exact same moment in time because this guy was aiming a gun at him at the same moment that I was driving the truck through, right? So they can do that thing where they kind of pin it on each other. Courts are basically not going to allow that, right? And again, they're going to apply different reasonings. Probably the most classic is they add a how requirement here, when and how it did, right? And this is kind of how you get around it. So they say the victim would not have died when the victim died and how the victim died, but for the defendant's voluntary act. And by adding this kind of how requirement in there, right, it's like, okay, well now we can distinguish between the truck hitting the victim and the bullet hitting the victim. And now we can say they're both the actual cause, right? So this is how courts deal with this, but the real takeaway is, and again, courts apply different reasoning. Some courts are going to kind of borrow the substantial factor test from tort law, but that runs into problems. The ultimate answer is, look, if we have that situation, concurrent sufficient causes all we need to know is we can say that both are the actual cause, right? That's just kind of the nature. But for analyses can get kind of tricky when we have when we're analyzing multiple actual causes. But if we have concurrent sufficient causes, we're going to say, look, you can hold both defendant as the actual cause of the victim's death, right? In situations like that. And again, the reason why that would be really rare is most of the time, right, actors are working together. If two people are shooting one guy at the same time, they're usually co-conspirators, accomplices, and again, that's a separate analysis, and we don't really run into these but-for issues there because they're going to be basically jointly liable in a way. They're kind of like co-defendants, right? So again, it's just exceedingly rare that we run into this stuff, but we want to know it. Also, we have obstructed causes, right? This is where the effort is obstructed by an external force, right? So say we have a victim standing, out there and our defendant, I don't know, right? Say we have a defendant who's going to kill this victim, right? He's got the intent to kill the victim and he's going to do it by throwing a knife at the victim, right? He's going to throw a knife at the victim, the knife's going to hit the victim, the victim's going to die. So he's winding up, he throws the knife, right? And as this knife is flying in the air, let's say a bolt of lightning strikes the victim and the victim dies, right? The victim dies from the bolt of lightning before the axe or the knife hits him, right? So he falls over and he's dead and the knife that's been thrown sails past the victim. Right, well in that case, right, obviously the effort, right, the defendant's effort to kill, right, the defendant's voluntary act to kill was obstructed by an external force, right? And in that case, we would say if that external force obstructed his effort, right, then he's not the actual cause, right? The lightning is the actual cause there. Of course, we can't hold lightning, right, liable for crimes, right? But the idea would be in that case, actually, the defendant is not the actual cause, right? We can't say the defendant is the actual cause if his effort is obstructed by an external force. So in a situation like that, again, it's kind of similar to this defendant shooting and missing, right? Probably would still be attempted murder, and we're going to talk about attempt as a crime later on down the line. So just remember, because you're not liable for one crime doesn't mean you're not liable for any crime. But again, in that case, you wouldn't have actual cause for murder with an intent to kill because that victim did not die due to your throw of the knife, right? That victim, we cannot say that that victim would not have died but for the defendant's voluntary act, right? So in that case, we say he's not the actual cause. Okay, I think that's enough with actual cause. Again, these issues are pretty rare. You want to be aware of them. The main idea is, right, this language right here. This is why we're adding that. When it did and potentially how it did, right? All of that is to deal with multiple actual causes, right? But again, we can just move to proximate cause because proximate cause is usually where you're seeing issues with causation, especially in criminal homicide. And it's more akin to kind of the example I opened with. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first-year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying, and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.